Hi, all. Today we're discussing plea bargaining, which could be most of this course, since 95 to 97% of all defendants plea rather than going to trial. And the prosecutor, as Michelle Alexander notes, is largely in charge, not the judge, not any other player. Because the prosecutors are free to dismiss a charge for any reason or no reason at all, and can conversely file new charges against the defendant if they're not cooperative. There's very few rules involved, and because of the war on drugs and the increased mandatory minimums, the prosecutors have even more power, more bargaining power. Those minimum statutory schemes give them incredible power to threaten, to make sure that they plea rather than risk going to trial. And by loading up with all sorts of additional charges, whether they have the evidence or not, it encourages them to plea and, very importantly, to give evidence against other potential defendants. That, as the US Sentencing Commission said, quote, the value of a mandatory minimum sentence lies not in its imposition, but in its value as a bargaining chip to be given away in return for the quote, resource saving plea from the defendant, meaning saving time in investigating other defendants. The problem is, it's very hard to challenge that discretion. As Alexander notes, at least one case, Armstrong v. United States, there was evidence that prosecutors were treating black defendants differently from whites in that prosecution. But when they asked to bring the lawsuit, the court said, provide us the evidence, and then we'll let you do discovery. Now, the problem is, as if you understand that discovery is where you collect evidence, they were told until you collect the evidence of abuse by prosecutors, we won't give you the power to collect the evidence. A somewhat catch 22. And this was despite outside research, in this case, the San Jose Mercury News. They had looked at 700,000 criminal cases, looking at crime, criminal history, and found that similarly situated whites were far more successful during pleas than African Americans or Latinos. Now, from the text, to talk about plea bargaining, you have to talk about the right to have a trial in the first place. This goes back to the case Duncan v. Louisiana in 1968. In that case, many crimes were not given trials. They often were just put before the judge. This was Louisiana, which, just a side note, had largely derived its codes from France rather than Britain, where judge run trials were far more common. But in this case, the court extended the Sixth Amendment right to say that a trial is fundamental to the American scheme of justice, that the right to the jury prevents a quote, oppression by the government, and it prevents unchecked power. So now, the thing is, while 49 of 50 states generally gave the right to trial, there was the issue that Justice Harlan, raised in dissent, noting that trials can be fair without a jury. And one of the issues here is that, and he raised this even back in 68, that many people weren't going to trial at all. Most trials aren't settled by the jury, it's done through plea bargaining. So, why is the majority making juries so fundamental? Now, there is the counter argument that says, while most people don't go to jury, the threat of going to jury by the defendant is their bargaining chip against prosecutor, that if the charges are unfounded, they can take their chance with the jury of their peers. But Harlan does raise this issue even then, that as so few cases go to a jury, what do we mean by a right to jury? And, we also have the issue that people are often not released before trial, that they can't make bail. There is the Eighth Amendment that says no excessive bail, but for many people, what that means, how the courts have interpreted that, have left many in trial, in court, in prison for months and months before their final determination. Now, plea bargaining itself, as we said, is very flexible, but for the defendant, who often are represented only by a public defender who has few resources to research the case, make an argument, all the public defender can do is negotiate the best plea possible. And here's the question: if the prosecutor has so much power, if it involves so much, threats and potential coercion, is it constitutional? And that was decided in the 1978 case, Bordenkircher v. Hayes, where the court looked at the issue and said, this was a case where somebody was given after negotiations a sort of, like habitual offender designation, which upped their potential sentence to a life term. And having had that added because they refused to plead to a lower plea, they said this was a form of coercion, of blackmail. But the court said, look, this is all part of the give and take in plea bargaining. They noted previous cases had allowed harsher indictments if defendants, like bargain in certain ways. It's okay for prosecutors to, quote, persuade the defendant to forego his right to plead not guilty. Blackman's dissent is interesting. He's skeptical of the idea that there's no vindictiveness and there's no difference between a sentence offered between 5 years versus life. Now, what he argued for as a solution is interesting. He didn't say no plea bargaining. He just said prosecutors have to bring all charges initially and bargain down from there. That, in his argument, would make the bargaining process more transparent. That the prosecutor, looking at the politics of it, would be accountable to the public for bringing harsh charges for minor crimes. They couldn't all go, hey, we just charge people with minor crimes when initially they were threatening far harsher crimes. Powell in dissent also noted that, there is the question of whether the prosecutor would have brought a habitual offender charge without plea bargaining, and suspects not. He, in this case, argues that there should be some limits on the plea bargaining system. But he also hedges and says he doesn't want to interfere too much with the plea bargaining process. But all of this goes to very clearly what is involved in a valid plea. The judge has to inform the defendant of the penalties and consequences of their plea. They have to determine that the plea is voluntary. They have to disclose all plea agreements to the judge, and the judge can accept or reject the plea, although generally goes with any plea agreed. But here's one of the questions that go into the plea bargain. At trial, the prosecutor has to disclose any information they have to the defendant. But how about during plea bargaining? And in US v. Ruiz in 2002, this was a case where the defendant wasn't given all information about problems with witnesses against them. And Justice Breyer for the court said, plea bargains, however, whatever may have been involved, you waive not just your right to a trial, but any constitutional protections associated with trial. So if you agree to a plea, you waive any rights you had to information. And just because you didn't have full, complete knowledge of the relevant circumstances, that doesn't change the nature or bindingness of the plea. Because they argued otherwise, if the government had to disclose all information, research what they know, what they didn't, they would lose many of the advantages of a plea, which is to quickly get through cases. Now, whether we want that sort of economy of our criminal justice system is an open question, but that's what the Supreme Court looked at. Now, here's a different question. What happens if your defense counsel really didn't give you very good advice? What are your rights then? Lafler v. Cooper decided the same as US v. Riaz. In this case, the defendant rejected a plea bargain on advice of counsel and was convicted at trial and received a very harsh sentence, much harsher than the plea agreement. Now, because the court agreed that the counsel's advice, quote, fell below the standard of adequate assistance of counsel guaranteed by the Sixth Amendment, would reconsider the case. And the Kennedy decision here looked at the problems where there had been issues of defendants accepting a plea agreement on poor advice from counsel, and they had like overturned those. In this case, the fact that they didn't get good strategic advice and rejected the plea counsel also counts for the right. Now, the argument here is that by Kennedy, it's not just we're trying to protect a fair trial. He says the Sixth Amendment applies to all critical pretrial phases of the trial, and the defendant deserves effective counsel on any appeals as well. This is where there's ambiguity about how much your rights are pre-trial. But at least on the plea agreement itself, the argument is you have the right to good advice. Now, Scalia in dissent says, you know, he doesn't think that competent counsel is required at the plea bargaining stage. Competent counsel is only there for a fair trial, and up to that point, he essentially says defendants are on their own. And one of the problems he has is interesting. He argues that Kennedy is making plea bargaining an integral part of our justice system, saying that it should instead be seen as, quote, a necessary evil. But he wants to pretend that 95 to 97% of people aren't going through plea bargaining. And Kennedy is being more realistic in that sense on saying, look, this is how most people go through our legal system. They deserve adequate counsel at that point. I did want to look at our final case, Rodney v. Class, which is a sort of interesting one, which is what happens if in between your plea and your appeals, the Supreme Court changes the legal status of the crime you were convicted of. In this case, Rodney Class was convicted of possessing firearms on Capitol grounds in the Washington, D.C., and he pled guilty to this. Now, the issue, though, was whether the firearms statute violated his Second Amendment rights. And in the meantime, in between his case and the final disposition, the Supreme Court in the Heller decision had declared the statute in question unconstitutional. So the question was, had he waived his right to contest his sentencing, given that, that possibility was always there? But in this case, the majority says because the status of his crime itself changed, he still had the right to appeal it. Now, Jed Rakoff, who's a judge as well as a writer here, wrote about why people do plead guilty. And he notes how the high percentages that plea. And he notes that plea bargains were once incredibly rare, and it really took hold in the US, but not in most other countries. It was only with rising crimes in the 70s and 80s, the Rockefeller laws in New York around early drug crimes in 1973, that you started to see mandatory sentencing, tough on crime judges elected, sentencing guidelines from Congress. That's how we started to approach 95 to 97% of cases being pled. But why do people plead guilty? Part of it is fear. Part of it is that the defense counsel, as we've noted, has so few resources. He notes that the average sentence for those making a plea in federal court is 5 years and 4 months, while those who go to trial get an average of 16 years. And given that prosecutors don't give defense counsel even time to do research, it really drives the process. And he argues that this is so one-sided that you end up with so much disparity in sentencing that he argues for judges getting more involved. And he does note that there are statistics via the Innocence Project and others that many innocent defendants are pleading guilty. Possibly as much as 10% of those pleading guilty to rape and murder didn't commit those offenses, which he argues is an incredibly horrific number that they're pleading guilty just to avoid the death penalty. So, why do they plead guilty? They sometimes have limited resources, troubled past. There's often a very rational cost benefit analysis. So, what does he argue for a solution? First of all, getting rid of mandatory minimums, giving judges more discretion, and we'll talk more about that in next follow up classes. There's also by bringing judges into the plea bargain process, which various states have experimented on, it would give more ability of the judge to really evaluate whether the plea is fair, that the defendant has had time to really research whether this is in their interest. He even argues for separate judges or magistrates overseeing the plea bargain process. And he also argues for recording plea bargain processes so that people can actually review them later for coercion. But his overall point is that we need to recognize how much plea bargaining has become the criminal justice system and how much we really have to think about reforms to avoid both the disparities, the severity, and the mass incarceration that really really came out of this system. Anyways, have a good day.